I know, but we've got an email question, Courtney. Why don't we go to that?
Doesn't tell any story. Okay, this one is from JJ. What if someone dies from their injuries before they're able to talk to a lawyer? Would their family be able to sue the guilty party on their behalf? A great question.
Yeah, JJ, I tell you what, it depends, and so this is what it depends on. First of all, if the injuries themselves were the cause of the death, then there's something called a wrongful death lawsuit. So the answer to that is yes. And so the way that you do that is you get among your family members and you make somebody the personal representative of the decedent's estate. So yes, they are able to file a lawsuit and proceed forward. There are some instances though where somebody dies from their injuries, they do not have, or the family does not have a recovery. So for instance, in a medical malpractice context, where the person dies and the person has no spouse and no dependents under the age of 25, there's such a limited recovery that's available that most lawyers will not take the case. But in typical fashion, if it's an automobile accident or a slip and fall or some other type of injury that causes the person to pass away and die, then yes, there is something called a wrongful death lawsuit that's converted from a general negligence lawsuit, and they are able to proceed and go forward. So I hope that answers your question tonight, JJ.
What's the statute of limitations on a wrongful death case?
Brian?
It is 2 years, and for medical malpractice, which Larry can answer this, it's a little bit different depending on when you identify the issue. But for general injury cases, it's 4 years, but if it is a wrongful death case, it is 2 years. So if a family member or a friend you know is killed, they need to have their family contact an attorney immediately. Number one, the statute of limitations. Some people don't even think about contacting a lawyer until it's too late. We get that pretty often on certain cases where they wait 2, 3, 4 years after somebody dies and gives us a call, and there's just nothing we can do for them. Even if they had a valid case, with the statute of limitations, if you don't have a lawsuit filed or a settlement within that time frame, then you can't do anything.
Is that the shortest statute of limitations there is? I'm just curious to know, because I don't know if we've ever talked about that. 2 years seems quite a short amount of time.
Well, in the law of Courtney, there's multiple different notices and statutes of limitations, so the short answer is no, that's not the shortest. There are notice of claims that have to be filed. For instance, under the current law, under the PIP and no-fault format, you need to seek medical attention within the first 14 days, and then you also have to have a doctor certify that you have an emergency medical condition to open up all of the PIP benefits. If you don't do that, then it's going to be very, very limited. It's going to be limited to $2,500 versus $10,000. Also, if you are involved with a governmental agency, some governmental agencies require a shorter statute of limitations or a shorter notice period. Courtney, we have cases that are up in Alabama, for instance, and some of the Alabama notice of claims are as short as 180 days. So wow. You have to be very mindful of where and when it happens. And like Brian said, if you have an injury or you sustain an injury or a family member sustains an injury and they're unable to communicate, you do need to reach out to an attorney who practices in the field of personal injury so that they can make sure that they meet all of the notice requirements, much less the statute of limitations.